Okay. Yes. Hello, Miss Juliana.
Hi, Bernice. It's so good to see you. Hi, Sohe. Thank you very much for coming.
Thank you so much, Mari.
Welcome. Bernice, you're looking great as always.
Yeah, you too, Ma.
Welcome.
So I can start now. Or we can start now. Hello, everybody. Good evening. Happy weekend, I guess. So my name is Bernice Asen. I'm a lawyer practicing in Lagos, and I'll be your anchor for today. So I'll just move on to the introductions. JIIPCC Mentorship and Internship Program is a quarterly intellectual property mentorship program for law students, young lawyers, and intellectual property enthusiasts across Africa. Mentees are offered opportunities to access valuable intellectual property advice, training, network, mentorship, internship, discussion forums, industry updates, and resource materials from experienced IP mentors. This program seeks to encourage the continuous intellectual property training, development, and evolution in Nigeria, Africa, and the world around. You can watch our videos by searching JIIPCC on YouTube and on Facebook. The objectives of the program: to provide easy access to intellectual property guidance, training, and resource materials for students, young lawyers, and IP enthusiasts across Africa; to facilitate dialogues and network among experienced and less experienced intellectual property practitioners and stakeholders; to transform mentees into intellectual property mentors and leaders of the next generation of mentees. Finally, to facilitate further intellectual property mentorship, internship, scholarships, and IP-related job placement for mentees. So I'll go over to introducing our mentors for today. The first person we have as a mentor for today is Mr. Amala Umenike. I hope I got that. Mr. Amala is the founder and is the founding partner of Bridgeford Attorneys and heads the Intellectual Property Dispute Resolution and Insolvency Practice Group. He's a graduate of law from the University of Nigeria, Nigerian Law School, and holds a master's degree in law from Queen Mary University, London. Amala is an experienced IP practitioner in Nigeria and regularly advises on contentious IP matters with particular interest in counterfeiting and trademark infringement cases. He has successfully represented and is currently representing several international brands and blue chip companies regarding IP cases in various courts and tribunals within Nigeria. As the head of the firm's IP practice group, he also supervises the management of IP portfolios for clients in Nigeria while advising and writing on IP laws, procedures, and practice in Nigeria. Mr. Amala is a member of the International Trademark Association, the Intellectual Property Law Association of Nigeria, IPLAN, Anti-Counterfeiting Collaboration of Nigeria, and the IP Committee of the Nigerian Bar Association section on business law. On the policy side, Mr. Amala is the team lead planning subcommittee of the IP Committee of the MBA section of business law. He's also a member of the Law Reform Committee of the Nigerian Bar Association, Lagos branch. Mr. Amala is a member of the technical committee that provided support for the Presidential Enabling Business Environment Council, PEBEC, chaired by the Vice President of Nigeria, through the Enabling Business Environment Secretariat on issues relating to ease of doing business in Nigeria. He specifically served as a member of the technical committee that reviewed the IP laws portion of the proposed Business Facilitation Bill, also called the Omnibus Bill. Mr. Amala also served on the World Bank and assisted the committee that provided support to the Enabling Business Environment Secretariat on crafting an insolvency framework for Nigeria. This bettered the insolvency regime as contained in the Companies and Allied Matters Act 2020. Mr. Amala regularly contributes to the World Bank's Doing Business booklet. We are pleased to have you, Mr. The next person is Mr. Max Ikumbe. Mr. Max Ikumbe is the founding principal partner of Ever Law Associates. He works extensively in the field of arbitration, ICT, and technology law and intellectual property. Max is the facilitator of the annual Information Technology and the Law course of the Nigerian Institute of Advanced Legal Studies since 2016. He has trained in the advanced intellectual property law courses of the World Intellectual Property Organization Academy. He's also an accredited agent of the Nigerian Trademark and Patent Registry and has conducted IP registration for businesses there since 2010. We are pleased to have you in our midst, sir. So we'll go over to the group presentation. We'll be starting with group 1. Every group has 6 minutes to present. Group 1, over to you.
Okay, good evening, everyone. Can you all hear me, please?
Yes, we can hear you.
Okay, thank you. My name is Enifome Akpolube. I am the representative for Group 1. I'll be discussing on the topic IP registration. Can you share the slide, please, at Gabriel? So basically, we'll be looking at IP registration today. We'll be discussing the different processes for registering the various types of IP rights. Now, IP registration is very important because in most cases, an IP right is protected only if it is registered, although there are exceptions. Looking at copyright and trade secrets, they do not have to be registered before they can be protected. So we'll begin with trademark registration. Mr. Gabriel, can you share the slides, please? So while I wait for him to share the slides, I'll just continue with the presentation. So about trademark registration, a trademark is a mark, a symbol, or a sign that identifies a product or service as originating from a particular company or producer and distinguishes that product from similar products. And for a trademark to be registered, it must be distinctive. It must not be a generic word or a scandalous or deceptive word. So it must be distinctive. So the first step to registering a trademark is to conduct a preliminary search. This search can be conducted online. However, you must note that the online portal was floated in 2017. It was launched in 2017, so it doesn't have marks that were registered before 2017. So in most cases, the search is done manually, and trust me, it can be very hectic. So after filing, I can't see the slides, please, Gabriel. Please share the slides. So after filing, I still can't see the slide though. So after filing, okay, thank you. We're looking at trademark registration now, so just, okay. So after conducting your preliminary search, you now file for trademark, you now file for trademark registration at the trademark registry. So this application must contain the name of the applicant, the contact details of the applicant, the signature or company seal of the applicant. And if the applicant is applying through an agent, it must contain the power of attorney. Trademark registration, Gabriel, what trademark registration. So if it's done through an agent, it must be, the power of attorney must be included in the application. So once this is filed, the trademark register would issue you an acknowledgement letter. After the acknowledgement letter has been issued, you then conduct a substantive examination of the application. And if satisfied that the application is in order, it would then issue an acceptance letter. If not satisfied, it would issue a rejection letter. So after the issuance of the acceptance letter, it publishes it in the trademark journal. And the essence of this publication is so that members of the public who have an objection as to the registration of the trademark must raise that objection. This objection is to be raised within 60 days of the application. So if at the expiration of 60 days, no exception, no objection is raised, the trademark officer would then issue, you a trademark certificate. Okay, next slide, please. Yeah, so international trademark registration. Mind you, the duration for a national trademark registration is 7 years. So after you've been granted a trademark, it lasts for 7 years and it can be renewed for a further period of 14 years from time to time. And as one of the mentors told me, that's Mr. Max, trademark is the only IP right that lasts for a lifetime. It lasts forever. So for international trademark registration, it may be done through the Madrid system. So an international application is filed through the Office of Origin to WIPO, designating the contracting countries they would wish to register. So WIPO registers the mark in the international register and transfers it to designating countries for examination based on their domestic criteria. So the mere fact that you applied through the Madrid system doesn't mean that it would be protected in all the countries to which you specify. The country would have to conduct a substantive examination on that application to ensure that it is in compliance with their own laws. Next slide, please. So the duration for an international trademark registration is indefinite. It is indefinite. Mind you, for an international trademark registration to be possible, you have to be granted a national trademark registration. So if in your country of origin, your trademark is not registered, it would not be registered internationally. And if it is revoked in your country of origin at the international level, it would also be revoked. So whatever happens at the national stage is replicated at the international stage. So internationally, it is protected for a lifetime, except it is revoked in your country of origin. All right, the next slide, please. Now, copyright registration. We all know that the copyright is an exclusive right granted to a person who expends some measure of skill, labor, or creativity in creating a work. So generally, a copyright, it does not need to be protected, does not need to be registered before it can be protected. Copyright protection is automatic upon registration. Next slide, please. So the duration for copyright protection, it lasts for 70 years after the death of the author of a literary, artistic, and musical work, and it lasts for a sound recording, film, or public performance, it lasts for 50 years. Next slide. So we'll be looking at the international protection of copyright. According to the Berne Convention, next slide, please, Mr. Gabriel. According to the Berne Convention, a copyright is automatic upon creation. So you do not need to register it at all. So for all countries that are member states of the various copyright multilateral treaties, such as the Berne Convention, the Marrakesh Treaty, the WIPO Performance and Phonographs Treaty, the WIPO Copyright Treaty, the Rome Convention, all these countries, once you create any copyrighted work, they're automatically protected in countries that are parties to all these multilateral treaties. Next slide, please. Next slide. All right. Yeah, we'll be looking at patent registration. A patent is an exclusive right granted to an invention, which is a product or process that creates a new way of doing something or provides a technical solution to a problem. And for a patent to be registered, it must be new, it must be industrially applicable, and it must it must involve an inventive step. So for new, it means that it must have a new feature that is not known to the existing body of knowledge at the time of the relevant application. Then for industrial applicability, it means that it must be manufactured, and it can be manufactured or applied to an industry, and it's not just a mere theoretical phenomenon. Then for inventive step, it means that it must be non-obvious to a person of ordinary skill in that industry. So in Nigeria, patent registration is granted on a first-to-file basis. In other words, if two or more persons have similar inventions, the person that has a copyright claim, the person that has an intellectual property claim over that invention is the first person to file, all right? So the first step for registering a patent is to apply at the Patent and Designs and Registry. So the application must contain the full name and address of the applicant in Form 1, then a specification, including the claim in duplicate. Now, the claim simply states what third parties can do or cannot do with the invention. Then it must also contain the plans and drawing of the invention, then a declaration of the true author of the true inventor, where applicable, as well as the signed power of attorney if made by an agent. That is in Form 2. Next slide, please. Then the address for service must also be included in the application. Now, a patent lasts for a duration of 20 years and it is renewed, and it must be renewed annually. So the limit is 20 years, and every year within those 20 years, you have to renew it. If not, it would lapse. Next slide, please. All right, international patent registration. A patent can be registered internationally.
You have 1 minute remaining.
Oh, it can be registered through the PCT, the Patent Cooperation Treaty. Next slide, please. Next slide. Okay, talking about industrial designs registration, and industrial design to be registered, it must be new, and the process involves a formal and substantive examination by the designs register, then the registration grace period of 6 months where it has been exhibited in an official recognized exhibition before registration, then renewal, and the duration for an industrial design in Nigeria amounts to 5 years, but it can be renewed for 2 consecutive times amounting to 15 years. Next slide, please. Okay, international registration of industrial, trade secrets. So a trade secret do not require any form of registration, as protection is automatic once they meet the requirements of it being a secret, it being of a commercial value, and involving reasonable steps that keeps the information secret. Next slide, please.
Good one.
Next slide,
just
please.
Round off now.
Okay, so we just talk about the challenges. Challenges with the IP registration is that our laws are very, very outdated. Our copyright law does not provide for provision or does not provide for protecting online content. And also there are administrative bottlenecks at the Patents and Designs and Trademarks Registry, and the registration in Nigeria is mostly manual instead of digital. Then let's move on to the recommendations. So we are recommending a review of the legal framework relating to intellectual property, and also adequate funding of intellectual property agencies and the use of technology in registering trademarks. Thank you.
Thank you. So group 2, you're next.
All right, good evening.
Good evening.
This is Jeremiah. I'll be presenting for group 2. All right. So very quickly, we'll be looking at very shortly, we'll be looking at IP, type of infringement, other copyright, trademark, patent, industrial design, trade secrets, and recommendation, conclusion, and the rest. So I believe in the past weeks, we've understood what IP means. It refers to the creation of mind, such as literary and artistic work, names, images, invention, and the rest. That's according to JIIPCC. So copyright, we say copyright is a legal protection a creator have over its literary and artistic, musical, cinematograph themes, sound recording, and broadcast work. That's according to Section 1 of Copyright Act. We move on to say a physical infringement of intellectual property refers to exhibiting or duplicating, offering for sale, or keeping in possession without the authorization of the owner of the work, any copy or any work that is protected by copyright or has previously originated from another source. This is well defined in Section 15 and 16 of Copyright Act. So we moved on to an online infringement of copyright. This is the act of sharing. Sorry. This is the act of sharing a protected work that's a protected work on the social media network without the authorization of the owner. So it is always good to ensure that if you want to use any work that is protected, you seek the authorization of the owner. I move on to, okay, we put a video here to just explain an online infringement of a copyright. This is a little skit of one comedian, that was created in 2020. And the same video, I don't know why it's not playing, I'm so sorry. And the same video was created in 2021 by another person. So this is just an example of infringing on someone's content, what you've developed yourself and someone else is taking over it. Okay, so we move on to, we say reproduction of any work in material form or making a copy is essentially the same for a practical perspective. As the Black Law Dictionary defined the word copy as an imitation or reproduction of any original work. Like the video I was talking about to you, there was an original work and the other person that created his own in 2021 made the same video. It's an imitation, and as such, it's a copyright infringement. Although there are some times when a fair use doctrine may be applied, in some cases, they would have to consider why the person is infringing, what the person is trying to benefit, and some other things like that. So we move to trademark. We say trademark are signs, symbols, marks, names, and the rest. This implies that trademark can be exclusively used by its owner or licensed to another party for use in return for repayment. Registration provides legal certainty and reinforces the position of the rights owner. We got this from IP for Business by Group 1, I think the second week. So we move on to say physical infringement of trademark. A very popular example is the case of Louis Vuitton and Louis Vuitton Dark. The Louis Vuitton Dark is a South Korean fried chicken restaurant that lost the battle against the clothing designer, Louis Vuitton. The court ruled the case in designer's favor, concluding that the restaurant's name, Louis Vuitton Dark, is too similar to the brand. So you understand what I was talking about? If your trademark or your business is similar to another person's business, then you find yourself infringing on another person, and that person that you're infringing on his business can actually bring an action against you. So we'll move on to say an online infringement of trademark. Similarly to the physical infringement of trademark, the online violation of brand's name, symbol, signs, or mark online means that the protected business registered under trademark is being violated. In online environments, however, where it is relatively easy to maintain an anonymous identity using offshore internet service providers or servers, for example, infringers can dodge legal action initiated by courts or administrative bodies in the country in which they have a virtual presence and in which they generate profit. We see that this is one of, should I say, an advantage of an infringer that is doing is, infringement online, because it's usually very difficult to get such a person. You understand what I'm saying? It's not very easy for you to get that kind of person. So we move on to patent registration.
You have 2 minutes remaining.
All right. A patent registration is an exclusive right granted for an invention to an inventor. So we say physical infringement of patents occurs when a person imports infringing copies, makes use, sells, or offer to sell a patent invention without a license of the patent holder, and therefore violates the patent holder's monopoly right to restrict other persons from carrying out any of these acts. So we say the online infringement is an infringement on patent invention can occur online where invention has, after being granted to the holder of a computer software or programmer, and such invention was carried out by another entity without due license. Industrial design, we say this is an intellectual property that constitutes an artistic aspect of an article. Basically, household goods, jewelry, packages, textile, they are the example that can benefit from industrial design protection. We say the physical infringement occur after registration for protection of an industrial design. The product will receive the legal protection, and the holder of the registration have exclusive rights. Any use of the registered design will amount to an infringement of the rights of the holder. We say an online infringement occurs when the rights that has been published or publicized online is being copied by another entity, different from the actual person that registered the business. So quickly, we say trade secrets. This is an intellectual property right that protects confidential information. This category of intellectual property are not registered.
You should be rounding up now.
However, they are protected through a non-disclosure agreement. Physical infringement, we say where a confidential agreement is entered into between the parties, the agreement shall bind the both parties. If any of the terms in the non-disclosure agreement is leaked, then either of the party should be responsible. Online infringement of trademark. A violation of trademark occurs when another obtains or exploits the secret of information using unfair method. I just talked about that. Okay, breaching a confidential agreement. Breaching a confidential agreement or inducing a former employee to breach the confidentiality agreement could be a violation. So our recommendation is that there should be more awareness. More awareness cannot be overemphasized. Enforcement of IP law too is very important. So our conclusion is that the purpose of this research is to discuss intellectual property and how the rights can be infringed. The purpose and the creation of intellectual property envisages the need to increase and protect the sanity of man's mind by ensuring its creation and protect against thieves. All right, we reference some work. We reference our work, JIIPCC and others. Thank you so much.
Yeah, thank you. Group 3, your honors.
Good evening, everybody. My name is Omolola Olayoye from Group 3. And Olamide will be sharing the slides. So Olamide, please, can you share the slides? So before she shares the slide, I'll continue the presentation. Our topic for Group 3 is intellectual property and enforcement. And in order to get a group description of enforcement of intellectual property rights, we'll be likening it to the concept of land ownership in Nigeria. So what a title to land and a certificate of occupancy means to a landed property owner in Nigeria is the same thing that IP rights means to a creative. So, when you trespass on a land, and when someone trespasses on your land, you can get remedies in the court. So also, when your rights are infringed on in Nigeria, you can get rights. And this is the process of enforcement in Nigeria. Enforcement is seen as a reaffirmation of IP rights, which seeks to challenge and stop an infringer. And this need to enforce these rights usually arises when an IP product has been infringed on. Next slide, please, Olamide. I'm on the next slide. So it arises when a product has been infringed on and the benefit or recognition is going to a wrong person other than the owner of the IP rights. Next slide. Fortunately, there are means of enforcing IP rights when they are infringed on, and most of these rights are entrenched in law. For example, now Section 251 sub 1 paragraph F of the Constitution of the Federal Republic of Nigeria as amended has provided that the Federal High Court has the jurisdiction to hear matters relating to copyright, trademark, patent, or IP rights. Almost all the IP on this slide we have the Merchandise Rights Act, and so ways in which we can enforce this IP rights we have. You can go through a cease and desist letter. Next slide, LMD. You can go through the cease and desist letters. You can go through ADR, that is alternative dispute resolution, and you have criminal and civil proceedings. So for a person to try to enforce this right, he has to be either the owner of the right that is being infringed upon, or the assignee of the right, or he must have the exclusive license in exercise of this right. So these remedies are when in a civil action, if you bring a civil action to enforce your IP rights that has been infringed on, you can either get damages, that is the court to try to return you to the position that you were before your rights was infringed on. Next slide, please. Or you have damages, you have injunctions. Yes, the courts can order the infringer to stop infringing on your rights. And we also have, next slide, please, Alamdi. You have injunctions that returns you back to your, next slide. Injunctions return and which stops the infringer on infringing on your rights. You have account of profits, which would entail the court to order the person to give an account of all the benefit for IP infringement, and it is reverted back. We have account of, basically there are 5 remedies in a civil action that you can use to enforce your rights as been infringed on. And then in a criminal action, in order to enforce your rights, the TRIPS agreement has made certain infringing of rights criminal. So if you infringe on a trademark, a copyright, or a patent, it gives the member states the rights to make these acts criminal. And the penalties for these acts include, you can go to jail for a certain period of time, or you pay an amount of fine you pay some amount of money as fines in order to deter other people from infringing on IP rights. So, however, this criminalization is optional, so it is left to the state. However, we have countries like Japan, we have countries like Turkey who have enforced, so we have criminalized some certain IP infringement. So in these countries, if you infringe on a right, on an IP right, you infringe on an IP product that does not belong to you, then you might have to pay some fine or a penalty or anything. So this, and then we have the online measures that you can take to protect your rights. And the basic one, the number one out of them, is the cease and desist letters. You send a cease and desist letter to a person who is infringing on your rights to stop the infringement, or else you will take other actions. Also, you can have online dispute resolution, which is mostly ADM, which is mostly arbitration. So, and then you have consequences of failure. If you fail to desist from infringing of this right, then the person who owns the right has the right to the person. If you fail to enforce your rights, it might result in a total loss of all the IP benefits and recognitions that will come from this right. So all the measures we have mentioned in this presentation on how you can enforce your IP rights, if you don't take these steps adequately and on time, you might lose complete rights.
Yeah, thank you. So we'll move on to the next group, group 4.
Okay, good evening, everybody. My name is Temitokwe Isaac, and I'll be presenting for group 4. My colleague Usman Sadiq would be sharing the slides. Usman, please, if you will, kindly share the slides, please. Okay, so while we wait for the slides, we're discussing the topic of IP and alternative dispute resolution methods, and which we all know as ADR. ADR is simply third party or let's say neutral mechanisms that parties utilize in order to resolve disputes between them. And in the context of intellectual property, when parties or a creator or a licensee, or in the case of an assignment, when parties enter into a contract that involves the transfer or license or exploitation of intellectual property, there could be instances where a dispute arises between parties, and ADR is one of those mechanisms that can be used to resolve disputes between parties. I see the screen. Someone is trying to share the screen. Okay, I'll just continue while we wait for the screen to be shared. So again, ADR refers to neutral mechanisms allowing parties to resolve their disputes outside of the courts in a private forum with the assistance of a qualified and neutral intermediary of their choice. In simple terms, it is a mode of resolving disputes or conflicts other than through the traditional litigation process. However, one point that must be borne in mind when it comes to ADR is that parties must equally agree to submit their disputes to this procedure, or else it could be mandated by a competent court. Can we have the okay? Yes, we can see the slides now. I hope we can all see it.
Yes, we can.
Yes, thank you very much. Next slide, please. Next slide.
You have 4 minutes left.
Yes, I'm aware. Thank you. Okay. So briefly, I'll just talk about the growth of ADR as an alternative to litigation. It was the multi-door courthouse idea was really propounded by Professor Frank Sander in 1976 when he presented the proposition at a 1976 Pound conference. And next slide, please. And in that presentation, it was widely regarded as a successful presentation because in the ADR movement for 3 reasons. And that is first, because it popularized the idea that disputes should be channeled into the most appropriate dispute resolution mechanism. Secondly, it promoted the advantages of alternatives to litigation, such as mediation and arbitration. And finally, the multi-door courthouse proved to be an effective mechanism for facilitating access to ADR services and traditional court processes. Next slide, please. Okay, next slide. I'll just jump into the types of ADR. Okay, so now there are different types of alternative dispute resolution methods, and the basic ones are arbitration, mediation, and conciliation. Next slide, please. Next slide. Now, for arbitration is simply a method of dispute resolution whereby the parties agree to appoint an arbitrator who is supposedly a specialist in the field for where this dispute has arisen. So, in a way, it's a way of choosing your own judge who can hear both parties on the terms of the dispute, and the parties believe that the arbitrator is able to deliver a judgment or an award that is both satisfactory to the parties because of his knowledge of that specialty. So the arbitrator hears both parties and their witnesses. So arbitration usually takes the form, or is quite similar to a traditional court setting where parties give evidence. They may even call experts, and the arbitrator arrives at what we call an arbitral award. And Usually, the arbitrator's final decision is both determinative and legally binding, which can be enforced by a court. Next is mediation. Mediation is a process where an impartial party, a third party rather, assists the parties in reaching a resolution by facilitating communication between them. Mediators often highlight the parties' needs and interests and help them overcome their impasses. The underlying word here is that a mediator helps the parties to reach a final settlement. It doesn't, unlike a judge, mediator does not decide who is right or wrong, is not coercive, and does not decide for the parties, but rather encourages them to agree to
You
a
have 1
settlement.
minute remaining.
Thank you very much. Expedited arbitration is simply a form of arbitration that is carried out in a shortened time frame at a reduced cost. Now, to the last one, which is conciliation. Conciliation is also it's quite similar to mediation. It's simply a procedure where the neutral third party helps the parties to agree or to conclude on a satisfactory dispute settlement. Now, the advantages of ADR to IP is that IP is generally known to be a technical subject matter because of the peculiarity of the terms, the peculiarity of the agreements, or the rights that are transferred under IP. ADR mechanisms such as arbitration and mediation are usually advantageous to such a dispute resolution cases. Therefore, the technicality involved in IP, the flexibility of proceedings is also a very good advantage, and the efficiency of ADR procedures are actually very, very advantageous. Now, one of the advantages of ADR resolution ADR to IP is that it can be costly, especially for a procedure such as arbitration, where you need to appoint perhaps sometimes more than one arbitrator, or where you need to bring in experts, or where the place of arbitration is not in your country. It may be costly in that regard. And ADR processes may not also serve as a deterrent to infringers, because sometimes the outcome may not be enforceable. And lastly, there is a potential for failure. And if the process fails, the parties may find themselves facing traditional litigation, something they were attempting to avoid in the first place. So lastly, our conclusion recommendation is that having a dispute resolution clause and policy when you are entering into these IP agreements and contracts can save you a lot of headache as an IP professional or a creative, or whatever you do that involves IP. Having a policy or a clause in your agreement or contracts can be very important, because it can provide synergistic benefits and minimize the risk of your disputes escalating. Arbitration, conciliation, and mediation operate within very different paradigms, and to adopt the most appropriate dispute resolution strategy for a potential or existing dispute, parties should understand the differences between the procedures and determine which is most appropriate to the circumstances of the conflict. Thank you very much.
Thank you. So group 5.
Good evening, everybody. I'm Olede Victoria, and I'll be presenting for the group 5. I will be sharing the slides. And since the slide is not being shared now, just go ahead from my side. Yeah, we're talking about, can everybody hear me, please?
Yes, we can.
Okay, thank you. We'll be talking about piracy and anti-counterfeiting. And here we'll talk about what is piracy, how to prevent, how to stop piracy. We'll talk about counterfeiting itself, what is anti-counterfeiting, and the measures to take to put a stop to it. So yeah, we say piracy refers to the unauthorized duplication of copyrighted content that is then sold at substantially lower prices in the gray market. The ease of access to technology has meant that over the years, piracy has become more rampant. For example, CD writers are available off the shelf at low prices, making music piracy a simple. So basically, piracy is the unauthorized duplication of copyrighted content. Could be books, could be music, could be movies, all these things that we can see, whatever it is that is being protected by copyright. Piracy refers to the unauthorized application of such content. Okay, so we say piracy is done in many ways. We see it every day, like video piracy, we see cable piracy, we see DVD, CD piracy, even books are pirated. For the DVD, CD, I know we are quite familiar with the this Nollywood movies. Most times they will package them, put a lot of movies, probably 4 movies into a CD, and you get to have them at a cheaper price instead of getting the movies themselves. That's actually piracy. Now, a lot of times, our foreign law textbooks are pirated with the claim that they are expensive, and pirating is a bit to make it cheaper for students. So this is the piracy of books now. We know a lot of books can actually be expensive, but then some people now come up to say they would copy the books, not acknowledge the right, and sell it at a cheaper price. So then people that want to get the books and cannot afford the expensive one go for the lesser one, and those are pirate books actually. So even works from Nigeria authors have been pirated and sold for prices way lower than the original price. Now, there is no single motivation for piracy. In fact, digital piracy has many philosophical underpinnings and root causes. A common refrain among pirates is that it's not really theft if you're simply making a digital copy. So this is about digital piracy. Like some people claim that since the original copy is still there, the original work is there. If they make a copy, it's not like they are affecting the original copy, so no one is harmed. But that's actually a shallow argument, because any authorized copy is a potential lost sale which harms the copyright owner. And of what use is copyright when the owner is being deprived of the economic incentives on his work? We know this is basis of IPL. We know why there are intellectual property rights and laws that guide them, because people want to protect their work. They also want to be able to have the financial advantage of their work to the exclusion of others, at least for the time being, whether limited or unlimited. They want to enjoy their work. So when these contents are being copied, their economic incentives, they are being deprived of the economic incentives of their work. So doing that on a massive scale can cause harm to the owner and reduce the incentives to create more content. When you know you create it and everybody gets it and at a cheaper prices, then you will not eventually get your own advantage. It's just like there's no need of creating another one. So when you get those incentives, actually it motivates you to create more content. So other pirates had raised the idea that all digital content should be free, and that the act of piracy is helping to free. So some people also come to say that all digital content will be free, and by making duplicates of this, or unauthorized duplicates of this content, they're helping them to free it, the authors. But it's actually still shallow anyways.
Victoria, we can't hear you anymore.
So, can anyone hear Victoria?
We can't.
No, I can't hear Victoria.
Okay, can you hear me? Let me continue. I'm in group 5. Can you hear me?
Okay, yes, you can, please.
Okay, I'll continue then. She was talking about piracy. So I'll start with okay, she already spoke about the fact that digital content should be the fact that there's no motivation for piracy, and that there are several causes of piracy, and that individuals caught or most content writers are worried about seeing the value of their investment disappear in the face of piracy attacks. So in order to stop this, they either remove the incentives, or they remove the incentive created for consumers to look for pirated content. So rather than look for pirated content, they look for the root cause, remove that so that they can actually look for the quality content. Then there's the education part, like you create awareness to the fact that piracy is a crime and it is illegal. And then there's legal and enforcement. There are various countermeasures that TV service providers. I'm so sorry that I'm not sharing the screen actually. I'm having an issue from here. There are several countermeasures that TV service providers can use to interrupt and remove pirated content. So I'm moving on to anti-counterfeiting because of time. So counterfeiting is basically the act of legally creating facsimiles of a product, like almost the same document or currency. In general, counterfeiters are accused of creating fake items at a low cost and selling them at a high value in order to make a profit. So they create substandard items, like there's an original item, then they create a substandard at a low cost, and then sell them at a high value, like probably the same value you would have bought the original. So basically, anti-counterfeiting is the act of opposing the illegal act of counterfeiting. Like anti-counterfeiting is you're basically against those that are doing counterfeiting. So basically, counterfeiting has the potential to create an enormous disruption in normal economics. Therefore, it's very important to oppose it. So it's important to protect product against counterfeiting, and it is necessary to maintain a balanced portfolio to actually prevent by making use of several kinds of rights from trademarks and designs to patents. And in order to enforce this, it's advisable to seek the protection of registered rights. I hope everyone can still hear me actually. So
Yes, we can hear you, but you have
okay,
2 minutes left.
okay, I'll finish up now. One measure to take against counterfeiting is to make sure that your rights are registered. Yes, ensure that your right to certain goods and products are validly registered. Then you watch, number two, you watch services and market surveillance. Right holders should actually watch the registers for new applications which could infringe on their own rights. They can validly take actions or receive notifications and take actions that can stop it or prevent this from happening. Then careful observation of the market is equally important. Internet use is the single most important gateway for marketing, selling, and distributing counterfeits. The internet is quite large and different things are being posted every day. You may not know which is original, which is fake, and most counterfeiters, they make use of the internet. This can be done through the assistance of specialized firms which score the web and filter the results in order to provide right owners with relevant findings. Then another way to prevent counterfeiting is to safety features and close chains of development to make it easier to recognize counterfeits. Yes, more and more products are being uploaded every day. And so in order to prevent it, you add safety features to your own product so that you can know the counterfeit from the original. And this could also include the use of labels. For example, your product that you are given instructions on how to carry. Yes, there are some products that you buy that you see instructions on what to do to know whether it's fake or original. Like now, there's this Skinny cream. If you know it on the carton, you see something like a scratch card that they say, scratch this and send the number to this to know if it is original. Now, if you do that, you automatically receive a message that yes, this is actually original, or this is fake. That's one way to actually prevent counterfeiting. Then it's important to avoid giving the impression that big corporations are unfairly attacking individuals or small companies that lack financial and legal resources to defend themselves. For this reason, the publication of successful actions must be carefully thought out. So basically, in conclusion, both piracy and counterfeiting are enemies of development in the society and should be curbed. They are both like not good for businesses. Entertainment industry specifically is being disturbed and limited by piracy, and effective measures as listed above should be taken to put the pirates in check instead of going about laying curses and making unnecessary announcements like some actors do. It's a criminal activity, so bringing an action against anyone caught in the act with the adequate punishment given will serve as a deterrent to others. That's all.
Thank you. So we'll go on to Mr. Amala to give us his comment on the presentation that we made.
Hi, can you hear me?
Yes, I can hear you.
Okay, yeah, good evening, everyone. Next presentation, and kudos to the various presenters. Because IP is broad, so you tend to find that no matter the time you are given, it's usually very short. So, but I think they did justice to the various presentations that were made. I'm not sure at this point what I'm meant to do. There were some questions that were sent to me, so I'm not sure whether it's to answer them or to comment on the various, because there are about 3 or 4 presentations, if I'm correct, and if you could please.
Yes, you can ask. Okay.
Hi, Mr. Amala.
Hi.
So what I think that you can do is that based on your practice, you can comment on the presentations from a practical perspective. And then we can also hear from Mr. Marks before we then take the questions, sir.
Okay, then, okay, I can do, so basically what I do, I mean, my area of practice is IP, obviously, but I would say my area of interest and what I do is IP infringement cases and anti-counterfeiting. You know, that's my core area of expertise as a person, not as a firm. So I would probably comment on the presentation that had to do with piracy and anti-counterfeiting, right? So, which we know it's a big issue, right, in Nigeria. I did a paper sometime, and when I was doing that research, I found that quite a number. In fact, I recently gave a talk in Cameroon and to enforcement organizations. And when we looked at the statistics, I saw a frightening statistic that said that about 60 to 70% of the drugs in Nigeria are fake, and that's very frightening. So it goes to every facet of our economy. And I mean, as an IP lawyer, you say, oh, that's good because that means there is a lot of work. But as a country, as a nation, I'm not sure that's a very good thing for us. You know, you look at brands, especially the luxury brand, I can tell you from experience that 80%, at least 80 to 90% of the luxury brands we have in Nigeria, maybe if you check yourself, the watch you are wearing, the jewelries you are wearing, they are probably fake, you know. So like I said, these are all frightening statistics. And I tell you what that does. It stifles the economy, right? It stifles the economy in the sense that brands wouldn't want to come in. I was recently talking to a particular brand. It's a very well-known brand. If I call the name, you know it. And the luxury brand. And I was saying, why don't you come to Nigeria? You know, they don't have any outlet in Nigeria. And I said, Amala, look, if we come into Nigeria, the counterfeiters will chase us out because 90% of our products that's been sold in Nigeria are counterfeits, and that if you want to, that the guys who want to buy the main products will usually come to London or to Paris to buy those products. So, but you know, the point is, as an IP practitioner, how do you then fight, or how do you then protect the interests of your clients, which are what they would usually engage you to do in order to be able to stem against the tide of this counterfeiting, and in order to be able to protect the interest of your client, the rights of your client, because counterfeiting actually, it's trademark, it's IP infringement, whether as a copyright infringement or as trademark infringement or as an infringement of the designs of your client, it's IP infringement, you know. So how do you protect that? And from experience, I can tell you that you typically divide it into 2, right? So you either go, it's 3 actually. So 2 would be either or. or you decide to do it together. Either you follow the criminal route, which is initiating criminal actions and criminal procedure against these counterfeiters, or you go through the civil route, which is to initiate civil actions or civil procedure against the persons. So what we typically do is, say a client comes. I give you an example. Okay, because of client attorney privilege, I'm not supposed to mention names, but say a client who is into automobile comes in and says, oh, we're having serious counterfeiting issues in Lagos or in Onitsha or in Kano State. The first thing that you do, of course, would be to, or in terms of piracy, somebody publishes a book, say Penguin, that's the publishing company, or any of the other big Oxford Press, they would usually have people who pirate books written by authors under their publishing company, and they would want you to take action. So the first thing you do as an IP practitioner would be to do an investigation. So in my firm, we have full-time investigators who are on our payroll and who are staff of our firm. In some other firms, or as an IP practitioner, you can engage outside investigators, or there are also companies who do that. So they will do investigation, and gather information. Because say you want to write a cease and desist letter, or you want to take an action, you need to have information that will guide whatever thing you are doing. So these investigations will then reveal maybe the shop address or the warehouse of the person. But before then, you find out that the first thing, even before investigation, the first thing you have to do for your client would be to audit the rights of your client, or audit the IP assets of your client, to make sure that they are indeed even protected in the first place. I've had an experience where a client said, oh, our products were being counterfeited. And then when we did that, we found out that they didn't have trademark registration at all, in respect of their brand in Nigeria. And even though under common law, you can use the thought of passing off as a basis for which you can launch an action. In practice, the truth is, for some of these regulatory agencies, they are not IP savvy. So once you don't have your trademark registration, they will tell you that they can't do anything. So it's quite important for you to be able to, first of all, audit the rights of your client's portfolio and make sure that they have the right registrations and the right protections. And then after that, you then carry out your investigation with the information that you have then garnered. You would decide whether to take civil action or criminal action. So if you decide you want to do it yourself privately using your private law actions or private law rights, then what you then do is to, typically you start with an anticounterfeiting, applying to get an anticounterfeiting order, to allow you to seize some of those infringing products. I tell you from experience, if you read textbooks and if you read materials, it will appear that anticounterfeiting orders would be granted to you and you'll be allowed to go and seize the infringing products and then bring them to court as evidence of the infringement, because you don't want those things to be destroyed. However, from experience, what has now happened, I guess as a result of the fact that people have been abusing anticounterfeiting orders, is that judges have now become very reluctant. So either sometimes they grant anticounterfeiting orders, and whether in copyright cases or in trademark infringement cases, and by the way, anticounterfeiting orders from the English locus classicus that derive from that name of, from the Antopila order that Lord Denning gave, actually derive from copyright cases, But what judges now do is that they either do not grant it, they find an excuse not to grant an Antopila order, or what happened to me recently, although at the end of the day I was able to convince the judge, was that they will tell you that they will grant you the order, but they will only allow you to go and take pictures of the infringing products, and then you won't take away the products, So it depends on your power of persuasion and your ability to convince the court that, look, if you allow that these persons are very unscrupulous, because if you go into practice, you find out that these infringers and these counterfeiters are very unscrupulous. And when I mean unscrupulous, they are very unscrupulous. They can even be very dangerous, So with that in mind, you will probably be able to convince the judge to grant you an Antopila order. Like I said, Antopila orders are nowadays being abused. I'm involved in a very controversial case. In fact, we have about 15 court matters. We've gone up to Supreme Court in that case, where a judge of the Federal High Court, granted an Antopila order against my clients. My clients are the owners of the trademark, but a particular gentleman was able to, unlawfully mislead a judge of the Federal High Court and convince that judge to grant an Antopila order against my clients, and my clients, one of them is a very big multinational company, very popular. And this particular gentleman then used that Antopila order to come to the warehouse of my clients and took away goods of about 400 million naira, and sold some of them even before they got to court. The matter, we have about 15 to 16 court matters in respect of that. So that's an example of where people have abused these Antopila orders, and which explains why, because it's obtained as party. So that explains why judges are now very reluctant to even grant them. So, but after obtaining that, you then go ahead and execute, take away the products, take it to the court, and go through the process of proving your rights in court. And if you get judgment, you then seek an order or the leave of the court to destroy the goods. Conversely, or even you can do it simultaneously, is that you report to the various regulatory agencies. So it can be NCC when it comes to piracy issues. It can be FCC-PC, who is a successor of the CPC, that's the Consumer Protection Council. It can even be the police. I know somebody mentioned the Merchandise Marks Act, so with that, under that, we use the police quite a lot. I use Interpol quite a lot. I make reports to them using the provisions of the Merchandise Marks Act. It can even be EFCC, because EFCC, one of the powers they have relates to intellectual property matters. You can report to SON or NAFDAC, depending on whether they have, whether their powers falls within the ambit of that particular, or the purview of that particular case. And then they will take action, most probably arrest the infringer or invite him for questioning, search the premises of the infringer and take away the infringing products. And then they would file a criminal action against the infringer. What happens in practice most of the times is when we succeed in getting the infringer and also getting the infringing product, a sort of plea bargain, is entered, where the infringer would undertake not to carry on with the infringement, and then the police would agree not to prosecute the person. However, what I can tell you also is that after, especially my brothers who are into trading, once you leave them, the next thing they do is to go back to their their old ways. You know, I have a matter that I'm doing now. A gentleman had written an undertaking to us saying that he was not going to continue it. Only for us, I think 4 or 5 months down the line, the same gentleman ordered a shipment of fake products from China, and we intercepted that, and we had to rearrest him, and we're about to, the relevant authorities are about to prosecute him. So that's that, you know, that's the process for me from a practical perspective as on how we tackle these issues of regarding counterfeiting. You know, one thing that we we're doing is some level of advocacy and trainings for these relevant government agencies, so that, you know, there would be, because the problem is that there appears to be inaction on the part of these regulators, which has led to the unabated rate at which people have been counterfeiting products. So as much as possible, with pressure groups such as the Anti-Counterfeiting Collaboration, we hope and we will continue working towards ensuring that this cankerworm of counterfeiting is eroded from, at least to a reasonable extent, from our place. So that's my take from a practical perspective on anti-counterfeiting and in relation to IP. Yeah.
Okay, thank you so much, sir, for your contribution. We'll move on to Mr. Marks to make his contribution to. Please.
Yeah, thank you, Benis, and of course, Juliana, and thank you to my colleague Amala, who has given us some very incisive and very practical discussion on the topics. And I thank all the groups that presented. I listened very attentively when the groups were presenting, and I was quite delighted with the quality of work that was put into your presentations. And even though you had to present in very limited time, but I think you all did some justice to the topic. I also noticed that my Egbon for Larry Naluko is also on the call. So, Tualisa, my hand the ground. Okay, so I'll just go through quickly since I see we are pressed for time. So since Amala has done a good job in particular bringing a very practical perspective to it, I just want to point out a few things which I think is good to always have in mind. You know, in respect to the 3 main areas we're talking of: registration, dispute resolution, and enforcement. So for registration, I believe it's been very well covered that with copyright, it doesn't require a registration for the right to inure to the author once you have produced a work that is a subject of copyright and you fixed it in a medium where it can be appreciated by other people. Automatically your copyright in that work immediately subsists without the need for a registration. However, it's always important to point out that while that is the law, there's also the provision for compulsory or voluntary deposit, which is not a bad idea, because one, it helps you to establish with some higher level of certainty the date of creation of your work, if not anything else, that's of some value. And then sometimes, I mean, I was still in Federal High Court just 2 or 3 weeks, or maybe last month or 2 months ago, and I still heard a judge saying in the Federal High Court that a copyright claim could not succeed because the person did not attach copyright registration certificate. So it's sad that despite how many times they have said this thing, our judges still persist in ignorance. But sometimes you just don't want to put your client's case through all that trial by error and start going on appeal. So sometimes I just tell people it's better just register and get the certificate and just, not register now, but do the voluntary deposit, get the certificate and just be on the safe side. For instance, also, Mr. Mala has spoken about some of the enforcement measures you can take, which I have to talk about. So one of these enforcement measures is what we call border measures or customs. Use the customs to stop the goods at the port. Say, for instance, I've had a practical case where somebody went and produced textbooks written by my client mass produced them in China and was bringing them in. So by the time you go to the customs at the port, you can tell them I'm the owner and all of that. But if you don't show them something, they will not attend to you. So that also becomes another reason why you need that certificate of voluntary deposit and why it becomes important. Then, of course, we know that for trademarks, you need to register, to enjoy trademark protection. If you don't, then you can still go under the common law right of passing off, which is slightly more difficult. You have to prove a lot of things that the production of your certificate of registration, if you have registered your copy or your trademark, would obviate the need to do that. Yeah, okay, I see a question. Is there really a difference between notification and registration in copyright? Yeah, well, there is, because some jurisdictions have some sort of registration requirement. So, for instance, say in the US, there's some sort of a registration requirement, even though I think it's for litigation purposes and some other purposes of that nature. But however, at the baseline, the notification of what we call voluntary deposit is not mandatory in law before you write any. Well, like I said, sometimes wisdom just dictates that you undergo that process, particularly if you're headed into a dispute scenario where you have to either challenge counterfeiters or you're about to go to court for infringement. It's wiser to just get that voluntary deposit certificate, even though I think the Nigerian Copyright Commission, the way they give it, they almost make it look like it's a mandatory registration requirement. But again, it might just be them trying to promote their own services and raise revenue for their office. So I've mentioned about trademarks. So I also talk about patents and designs. Now, patents and designs is a higher requirement for registration because it's, just 2 weeks ago, I think last week I was speaking on a webinar of the IP Society of Nigeria, where we're talking about monetization of R&D and IP product, IP works of universities, and how that could become a source of revenue that would solve all this ASU and government fight that never ends. So one of the points that came up there strongly is that when it comes to university professors now, or universities as well, universities are set up to disseminate knowledge. But in a sense, patent is set up to, in a sense, hold knowledge. So yeah, exactly what we're talking about was an industry-university collaboration where companies would sponsor universities to run research for them, develop new products and all of that, register the patent, and then there's sort of a collaboration agreement where the industry that, or the company that set up the research grant gets the exclusive right to use the patents and other IP coming out of that product, and in return they pay some royalty to the university. So we're talking about the tension between the company who wants to hoard the knowledge of that patent and the university professor who wants to quickly publish his new inventive discovery. So one of the challenges that arises is that with patents, if you do not register and you begin to run your mouth and you tell people about your inventions or you publish about it, then you lose the right to register forever. So it's a point you must make to clients that before you begin to run around, telling people about your new wonderful idea, of course, that's if you have gone beyond the idea stage, it's a proper invention, you have fulfilled all the requirements to, for a valid patent. Ensure you register a patent before you go to town. With trademarks, it is the requirement, the issue is less, because with the trademark, even if you don't register, anytime you come to register, you are good to go. Sometimes you can't even register some trademarks because they are not inherently distinctive. You need to have used it for a while, and then there's already an association. It has acquired distinctiveness over time, which simply means that it's not exactly inherently unique, but because you have used it over time, the mind of the consuming public has become attuned to recognize that there's a connection between that trademark and your product. So if you read the Nigerian Trademarks Act purely, it provides for Part A registrations and Part B registrations. So Part B registration usually is for those registrations that are not inherently distinctive but acquired distinctiveness over you. So with those, for instance, you don't have to register instantly. It's not mandatory, even though of course it is wise to register your trademark as soon as you commence business. But I'm just saying that to make that clear distinction between patent and designs and trademarks, and why you must register your patent and designs really early in the life cycle of your business model. Of course, that's you advising your client. So I'll quickly touch a few things about dispute resolution. Mr. Amala has also done a good job telling us some of the practical things. In fact, I'm currently embroiled in one of those things, trying to get an Anton Pillar order and the the judge is, is running all over the place and not wanting to commit himself to grant that order. We are also hoping to try to persuade him to give us an order that is limited in scope. So what we did in our case, say, okay, look, give us the order, but only lock the place down for 7 days and tell them to report back to court, because the nature of equipment we are moving against are not things we can move easily. I mean, these are really heavy mining and quarrying equipment. So rather, we're saying, give us an order to lock down the place. Of course, take pictures, do a proper inventory of all that is there, and let the defendant report back to court within that 7 days. So, but it's still quite some argument back and forth between us and the judge, who doesn't want to commit that. That's why, in fact, they are seeing clearly that we even have a letter where we are reported to police earlier, and police did an investigation and went to the trademark registry, and trademark registry confirmed that my clients had a trademark registration and the other people did not have any trademark registration, of that same brand. But like Mr. Malas rightly said, sometimes it's just persuasion, and then judges also have to be careful, because a competitor could easily use this to run your business aground. Imagine even if the person just comes to court and misleads the court, like it happened to his client. Now, even if it's just for 1 week, that could really disrupt, the business of a businessman. So, yeah, talking about dispute resolution. Yeah, so of course, for the primary IP rights, the jurisdiction for those disputes is vested in the Federal High Court. So that's copyright, trademark, patents, designs. You have to go to the Federal High Court. However, there's an interesting decision that my attention was drawn to by the book written by Mr. Mark Modi, a senior advocate of Nigeria designate. So he mentioned an authority of the Supreme Court that actually said, even for passing off claims, that because of the introductory words in the Trademark Act that says nothing in this act prejudices bringing an action under old common law. So he says, that authority now says, look, that the Federal High Court actually has concurrent jurisdiction with the state high courts in passing off matters. But however, when it comes to trade secrets, I still believe that I don't think I've seen anything in the Patent Act that is equivalent to what we see about passing off in the Trademark Act. So I still suspect that for trade secrets, I would believe that jurisdiction is vested solely in the state high courts, and I don't think the Federal High Court would have jurisdiction on trade secret matters. So, but that's just to point out what I think are some of the things that are not exactly regular about the jurisdiction of the courts when it comes to IP matters. Then I want to touch on that part that is very important, because I'm currently in Ibadan for the Chartered Institute of Arbitrators conference, and just earlier I had one of the sessions where I spoke about arbitrability. That's being the capacity to resolve IP disputes through arbitration. It's quite a hot topic on its own. And then just yesterday, Professor Bankole Shodipo, also a senior advocate of Nigeria designate, also presented and harped a little bit on the issue of arbitrability. And it's very important that while ADR and arbitration is applicable to IP disputes like any other dispute, you have to be careful, because in IP, there's what we call arbitrability, which simply means the capacity to be able to resolve certain kinds of disputes through arbitration. So one obvious example is taxation matters. The courts have said no. So far as Nigerian public policy is concerned, you cannot arbitrate tax disputes. But however, the courts have also made a distinction that because tax disputes don't come as tax disputes alone, they come in an envelope of a commercial dispute. The arbitration tribunal can make a distinction between the purely commercial aspects of the dispute, and that can be arbitrated, but the tax parts cannot be arbitrated. And of course, the reason behind the constitution is that tax is a public policy matter, and there's already a well set out framework for resolving tax disputes. The tax appeal tribunal, and all the procedure. You issue a notice of what they call the FRS issues you an assessment. Then there's what they call a notice of no objection. I can't remember the exact name now, but there's a procedure that culminates in the tax appeal tribunal. So, the reasoning in that is that because of that public policy element and the fact that there's already a well-defined resolution mechanism set up for tax matters, you cannot arbitrate them. So if we bring that same reasoning to IP, now the conventional thinking behind why IP disputes are not arbitrable is also largely on the same basis, that IP rights are granted by the state regulators or authorities, and they are in a sense a negation of the principles of competition law, because a patent, for instance, is a monopoly, which is a negation of competition law, which is a public policy matter, because the system that the world runs on, which is the capitalist model, essentially is open market or open economic system, is based on competition law. So if the state agencies negate competition law by granting you a monopoly, then the thinking is that arbitral tribunals who are not, answerable, as it were, to those state regulators should not, and are not courts set up by the Constitution, should not be able to interfere in the existence, the grant, the right of IP rights. So the same decision, however, applies. If an IP dispute comes in an envelope of a general commercial dispute, then the commercial parts of the dispute are arbitrable, but the existence of an IP right should not be the subject of that arbitration. Or what other jurisdictions have done is to say, some of the European jurisdictions have done is to say, look, an arbitral tribunal can go ahead and make an award that touches on the existence of an IP right. But however, that award must be limited in persona between the two parties. So the tribunal can say, look, the patent owned by Max, so far as this dispute with Amala is concerned, is invalid. But however, that does not bind the trademark or the patent authority of that EU country or other third parties. So for other people, that patent is still valid and but however, between me and Amala, that patent is invalid because of that decision. Some other jurisdictions, like Switzerland, have gone as far as saying, look, all IP disputes are arbitrable, and that any decisions coming out of arbitral tribunals on IP matters are valid and binding on the whole world. So it means if an arbitral tribunal nullifies your patent, for instance, then that patent stands nullified. So the argument Professor Sodipo made is that in Nigeria, and I agree with him, we can't find any clear-cut cases where the courts have actually made a decision on this matter of whether IP disputes, are arbitrable in that sense. But what he says is that from a practical standpoint, he thinks it is wiser that arbitral tribunals avoid touching on the existence, the validity of IP rights, because even if they do that, will it be binding? Would you take the arbitral award and go back to the trademark registrar and tell him, rectify your register because this arbitrator said this trademark is not valid or patent? And also he thinks it's not practical. Only courts can rectify those registers even under the act. So because of that, it's something you have to watch out for and be careful in resolving IP disputes through arbitration. And then finally, I'll just say a few points about enforcement. So, of course, Mr. Amala has also spoken extensively about enforcement, particularly, from the counterfeiting perspective. It's actually a huge issue. In fact, I just like you said, I've also had clients who have just given up. They just think it doesn't work because, sometimes stopping counterfeiters is like, there's a game called whack-a-mole. A mole is that thing that, it comes out through one hole in the ground. You try to spank it, it jumps back in the ground, comes out through another hole. So sometimes the challenge is they are not able to really hit the root cause, the root source where these counterfeit goods are coming from. So you go to Alaba market, you lock down 5 of them, it won't change anything. There's a source where this thing is coming from. So except you can strike at that source, you might just be wasting your time. And typically the source is usually not in Nigeria, but maybe coming somewhere from China. And sometimes getting the Chinese, even using Interpol and getting the Chinese counterparts to to really cooperate. These investigations can be quite expensive and difficult. So some people have just given up about trying to catch counterfeiters, and all of that is a huge issue. So I'll talk about some other non-conventional enforcement mechanisms for IP rights. One of them, of course, is domain name dispute resolution. I'm sure in the course of the of this cohort, you'd get to hear more about that. But essentially, what domain name dispute resolution does is to give a quick and expedited channel for resolving trademark abuses using domain names. Like we all know, all websites actually are have what we call an IP address, which is like a phone number. So, but just to make those websites memorable, people, the domain name system, just like your phone book in your phone now, when you want to call Maxi Conway, you don't have to start dialing 080347. You have linked my number 00372435 to my name. So when you want to call me, you scroll to you type Maxi Conway and you dial Maxi Conway, but your phone is going to understand that Maxi Conway is linked to a number and it's going to call that number. That's how it reaches my phone. So it's same thing also with websites. All websites essentially have what we call IP addresses. So that's really the real locator of that website on the internet. But however, when you see www.julianaimam.com, the real thing behind it is 1902345, but you can't remember that every single time. So you simply type into your browser julianaimam.com, then your browser converts julianaimam.com to the 1902 whatever number and locates her website on the internet and produces that page to you. So because of that replacement factor, it's very juicy to use a trademark to replace those numbers. So it becomes easy that I'm not Wole Olanipekun now, but just imagine Anambra election is coming. If I could just go and register a domain name, www.woleolanipekun.com now, I mean, whoever loses the election would think he's looking for Wole Olanipekun to do his election petition, and he falls into my hands and I take his money. So that is one of the abuses that happens with the domain name system. So essentially, domain name system is based on trademarks. So once you can show that you own the trademark that somebody has used in a domain name, and you can show that the person has registered that domain name in bad faith and that he has no legitimate right to use that domain name, then there's an expedited arbitration process that takes top 6 weeks, and quickly give an order to the registrar of that domain. Sorry, these are technical terms, but I'm sure you get to hear them more in the course. But registrar is just the people who manage the domain name system, who sell retail domain names to the public. So you go to them, so you get that ruling from the domain name dispute resolution panel, and they order them within 10 business days to transfer that domain name to the rightful owner. So if I did that, for instance, Wole Olanipekun will go to the domain name dispute resolution tribunal, and they will order me, they order my registrar who gave me that domain name to transfer the domain name to him immediately, so he is able to control his trademark online. Then, okay, we've mentioned customs and border measures, so I won't talk much about that anymore. Mr. Amala also mentioned the FCCPC, that's the Federal Competition and Consumer Protection Commission. So the good thing about them is, and why I like using them, is that when you have a clear-cut case of counterfeiting, you don't need the court order. Once you go to FCCPC, they are able to raid. Once you can prove that there's actually a counterfeit in stock as at the time. So there are a lot of ways to do that. It's what we call mystery shopper. So you send somebody to go there to pretend he's coming to buy the products from them. He buys it, so at least you're able to take it, test it, and confirm that it is counterfeit, and then you can call them on the day of the raid and say, okay, I want to come and buy more of that thing I bought, and then you are sure it is in stock. If you go there with them, with their policemen, they'll be able to lock down that place and open investigation, and at least keep that counterfeit out of business for a while, pending when you can rush to court and get other orders, or at least get the police to also intervene in the matter. And then that way you're able to keep that counterfeiter out of circulation, even if you don't get a final judgment against him. Then, of course, he has also mentioned criminal infringements and some of the laws, so I won't go there. So the last I want to end with is what we call DMCA takedown orders. DMCA is the Digital Millennium Copyright Act of the US. Now, under that law, because most internet service providers, I mean the big giant internet service providers, are all based in the US. Under this US law, which is the equivalent of their own Copyright Act, they have a provision that says if you are an internet service provider, you must maintain a procedure internally where anybody who alleges that there's an infringement of his IP right on a website hosted by your company, then you need to review and, within a set number of time, take down that infringing article. So it's used more in the case of a copyright claim. So somebody takes your article and puts it on a website. All you have to do is to do what they call a whois search. Whois search simply is a search that tells you who the owner of a website is, who the internet service provider that is hosting that website is, and invariably most ISPs are either in the US or indirectly have a connection to the US. So if you can find that connection to the US, then you can check also for who within that organization of that ISP, the internet service provider, is responsible for attending to take down notices. You can write the take down notice, you put evidence to show that, look, I'm the owner of this copyrighted material. I published it on my website 7 years ago. This guy has copied it, pasted on his website without my permission, and you are able to able to get them to do their internal review and take down that article. So the big social media platforms also have a very established process, Facebook, YouTube, and the rest of them, to also do this. So it's also another effective way to monitor and police your IP online. I mean, it's quite efficient because you don't exactly need a court action to do that. So I think with this, I've very well run over my time. So I just thought it would be good to bring some of this perspective to this discussion. So thank you very much, Benis, and back to you.
Thank you so much, sir. Thank you. So we'll be moving to the Q&A session. So if you have any question, you can unmute your mic and ask. But before then, I'll be reading out some questions. How feasible is the domain/trademark infringement issues?
Okay, so can I just jump in and take that right away?
Yes, sir.
Okay, yeah, so yeah, it works very well, the domain name dispute resolution system. And now let me explain to you why it works very well now. Now, there's an organization called ICANN, that is the Internet Corporation for Assigned Names and Numbers. That, okay, well, maybe let me move back a little bit so I get a clearer context now. Now, the internet started in the 1960s. It was an internal research project of the US Army. So it was, first of all, called the ARPANET. So it was essentially just the US Army saying, how are we going to be able to have computers across, multiple locations, effectively collaborate, talk to each other, share documents and share resources? So that's how the internet began to form. Then, of course, the internet really took speed in the towards the late 80s. And then by the 90s, the internet was all over the place. So the internet, of course, like I tell people, is the full name is the Internetwork. So it's a network of networks. So that means there are many networks interconnected to other networks and interconnected to other networks all over the world. So when that started, it was essentially, yes, the US Army started it, but at some point, it became more like a private sector thing. So the organization ICANN was set up to, first of all, an organization called IANA, Internet Assigned Names and Number Authority, was set up to manage names and numbers on the internet. Like I told you, the internet works on numbers, but however, names are used to replace those numbers so that it's more memorable to be able to locate resources on the internet, websites, and other resources on the internet. So IANA was formed to be the authority, a private sector authority registered as a non-profit in California, the USA, to monitor, to manage the internet system. So ICANN, Internet Corporation for Assigned Names and Numbers, was subsequently formed because people now say, look, the US cannot own the internet. So ICANN is a more multi-sector body, not owned exactly by anybody, even though there's still arguments that the ICANN should be made a part of the UN. So the ICANN actually manages the internet functions. So what they call the root domain name system, which essentially is the what makes the whole internet work. Otherwise, without that root domain name system, then my computer will not be able to talk to somebody's computer in Japan. So because of all of that, the recognition was now made that, look, this fact that we allow people to replace the numbers of the internet with names is going to become a basis to abuse domain names. So because of that, I can't set up a consultative process under the auspices of WIPO, World Intellectual Property Organization, and they came up with what they call the UDRP, Uniform Domain Name Dispute Resolution Policy. Now, what they did on that policy is that, number one, because every registrars are the people who resell internet names and numbers to end users. So for every registrar who is going to be authorized to be able to sell names and numbers from the ICANN, you have to have an agreement with ICANN that says if a panel says transfer a domain name, you must obey within 10 business days, except there's a court order or a court suit that stops you from doing that. The second level is that as a registrar, before you sell a domain name to end user, you must also make the person sign an agreement that says if his domain name infringes on anybody's domain name, then he agrees to go to arbitration under the Uniform Domain Name Distribution process. So what that has done essentially is that anybody who's going to use the internet resources, you will have agreed to that arbitration automatically. So that is why I would say that the domain name system is very effective, because anybody, if you are going to use the internet resources, you must agree to this Uniform Domain Name Distribution process. And once you have agreed to it, if the dispute arises, you cannot opt out. And once the award is made by that special tribunal, the enforcement is easy because we are not going to look for police to enforce it. You just write to the registrar and say within 10 business days, transfer this domain name from Maxi Kongbe to William Landipekun, Senior Advocate of Nigeria. So it's a very efficient system. 6 weeks, you have your judgment out, because the procedure is essentially a specialized arbitration. There's no oral hearing. You make all your submissions on paper, they appoint a panel, and pronto, they issue a decision. So it's a very efficient system of getting and protecting your trademarks online. Thank you.
Thank you so much, sir. So the next question, as it relates to piracy, how can the government help to bring its enforcement / awareness close to the masses? Mr. Amala, you can help us answer this question.
So how can the government, sorry, I didn't catch that.
How can the government help to bring its enforcement / awareness close to the masses?
Oh, okay. I think that, I mentioned it a bit when I was talking, and it's through awareness campaign, I guess. So there are a lot of activities that are being done by the government, which I can tell you is not enough, So, and that's where some of these pressure groups, some of these organizations, such as the Anti-Counterfeiting Collaboration, the MBA, SBL, and various other organizations will come in. So if you ask me how the government would, to bring what the government would do, I would say first of all that they have to clean their own house internally, which is to become efficient. If you become efficient, I think that's the best form of PR that you can do. That's the best form of awareness that you can do, right? And I tell you why. You see, NAFDAC, under someone like Dora, and you'll be surprised how popular NAFDAC is outside the country. If you talk to enforcement agents outside the country, you would see how popular they are. It was as a result of the activities of Professor Dora, and I don't think she did a lot of PR, a lot of awareness campaign in terms of the fact that you have to look out for NAFDAC registration numbers. That was done, but I mean, that wasn't the entire thing that was done. But the effectiveness of such campaign that she carried out spoke for herself. I can see Mr. Aluko say that she did a lot of campaign. She didn't that much. Well, if you compare what she actually, in terms of PR, in terms of campaign, to what the successor did, that's Paul, you won't probably compare that. But for me, which is my personal opinion, I might be wrong, what she did was that her work spoke for herself. She did a lot of work. She closed down. Recently, I gave a talk to the regional body of organized by AFRIIP, the regional body of IPR enforcement, Interpol, and all that. And everybody kept on talking about the market in Onitsha. I think that that is the biggest. That's the drug market in Onitsha. That's the biggest open market where they sell drugs in the whole of West Africa. And she was able to close it down, I think, for about a year or so. That for me was the highest PR that you could do. And that for me was the highest awareness. NAFDAC officials were very efficient and very, very proactive. And so people knew about NAFDAC, people knew about NAFDAC registration number, people knew about the fact that you have to look out for such things, So for me, the best form of awareness, I can give you I don't want to start mentioning, because I work with a lot of these agencies. I don't know anybody who is here, so I don't want to start mentioning names, and then tomorrow they'll say Amala has said something against them. But the reality is that a lot of these government agencies do a lot of awareness program, a lot of campaign, and it turns out to nothing. So from a practical perspective, and that's my own opinion, that's Amalumike's opinion, is that we shouldn't even be doing so much of these awareness campaigns, but at least on the part of the government, leave that for private organizations, leave that for private pressure groups. Rather, face your work, become more efficient, become more proactive. That's the honest truth. If you become efficient, if you become proactive, if you do your work, I think your work will speak for yourself. then leave PR, leave awareness, leave for lawyers, leave it for interest group, leave it for anti-counterfeiting collaboration, leave it for MBS, leave it for even the associations, the various industry associations. They are very interested in making sure that the stem of counterfeiting is stemmed down. Even the brands on their own, some of them pay us to go out there to the market to help them to, sensitize the general public regarding their brands. So for me, I mean, maybe I'm too, probably because I've seen some things, and I'm no longer very optimistic about the way things go. So forgive me if I have some very controversial views, but for me, if you ask me, I would say that in terms of what the government can do in order to create awareness, in order to bring these things closer to the masses, is for them to do their work. That is the best form of PR, that can be done.
Okay, sir. Thank you so much, sir. So the next question for Mr. Marks. What aspect of industrial design can be protected via copyright? And to what extent can industrial designs be protected using copyright?
Okay, yeah. Thank you for that question. Let me just be sure I calibrate my brain properly for that. Yeah, so there's a distinction really. So what copyright protects, let me try to pull back and look at it from the background of it now. What copyright protects is the expression of original work. Now, however, with industrial design now, what industrial design is out to protect is unique aesthetic features. That's things you can see or touch or interact with about a product that makes them stand out and makes them appealing to the end user. So because of that, and I think there's a clear provision in either the PDA, that's Patent and Designs Act, or in the Copyright, I think it's the Copyright Act that says, where, however, what you have done, say for instance, you have done a creative design that is going to be used as a mold to reproduce many articles, then at that point, what you can use to protect that would be industrial designs. Because if you do, for instance, a mold of a sculpture, for instance, and that sculpture is just to be sold, is to be appreciated as a sculpture, is a different matter. But if the sculpture is used as a mold that you use to, reproduce many other designs, or many sculptures you sell, like I said, I'm just struggling to get that decision, but there's something of that nature. So what simply means that what the copy, where the industrial design is itself what you are using to manufacture multiple products to sell, then you have to protect it at that point with industrial design. So there's, I believe, a case in Professor, Professor, I call him Professor John Asien, the current DG of the Copyright Commission. So I believe there's a case there where he talks of an English case where someone used created I think a mold of like a disc used to produce what they call this sport now, javelin. There's a sport where you spin around disc and throw it, not shot put, not javelin, discus. I think that's the name of that particular sport. So he created a unique mold which they used to reproduce that discus set for sale. So he had an issue where he sued for copyright infringement for somebody who had reproduced that mold. And I think other laws that were similar to our current Copyright Act, the court said no. His remedy would have lain in industrial designs. And why that is important is because remember, with industrial designs, you have to register. And not only do you have to register before you disclose that design to the public. So if you have that kind of design and you have not registered it, you disclose it to the public, you have already started using it to multiply and make other products and you sell, then you cannot fall back on copyright at that point because your remedy will lie only in industrial designs. So I'm sure I've not done exact justice to the question, but since Mr. Following is here, I think I'll plead with him to also come in and help me out, because I know I've not done exact justice to that question. And of course, Mr. Amala too might also be able to help us to do some more justice to that question. Thank you.
No, I think you are quite right. The idea is that, copyright, if I recall correctly, it's Section 1 of the Copyright Act. It's an explicit provision, of works that are eligible for protection. The reality is that copyright and industrial designs they don't run together. And the reason is that it should be Section 1 of the Copyright Act, if I check, but there's an express provision I can remember that says that if you intend that it will be a model, or it will be, so to speak, mass produced, then it will not be eligible for copyright. And the idea of, the protection that's offered under industrial design is the word industrial, So the protection, and that happened to me. A client came, and then they were talking about copyright. And when we looked at that, they had the right, because like you rightly pointed out, copyright is something that is, the right is not acquired by registration, but the moment that an idea is expressed, that's the right becomes automatic. So that's that. The right in relation to industrial design does not go with copyright. Once you have decided that you are going to use that particular work as a model for mass producing other things, then it's one of those things that are ineligible for protection under that, So that's the point.
Okay, thank you so much, sir. So the final question that I have is, how can one become an accredited agent under an accredited trademark agent in Nigeria? Mr. Mark, please.
Well, trademark agency now at the point, I don't think under the current government is of doing business initiative, it doesn't really exist anymore, or has never really existed, because there's never been any law that truly provides for trademark or patent or any kind of intellectual property agent. Some countries have strict laws. So for instance, in the US, I was reading recently, they're about taking action against some trademark and patent agents in the US, who are allowing people from China to use them to file applications in the US Patent and Trademark Office. But in Nigeria, our law has never limited dealing with the Trademark and Patent Registry or the Nigerian Copyright Commission to lawyers or to accredited professionals. So there's really no basis for that. But before this time, what the Trademark and Patent and Designs Registry had done was to create an online portal. And that online portal, you could only use it if you paid some accreditation fee and you were accredited on that portal. It ran for a while, but sometime in 2019, based on the ease of doing business, the government has said no, just the same thing they did with the Corporate Affairs Commission. I said no. Anybody, a member of the public, should be able to come on that portal, register, create an account immediately, and go ahead to file his IP right. So at the moment, there's really no requirement. All you have to do is just go on the website iponigeria.com, create an account, and you are good to go. So it's one of the areas that one of the challenges for you coming to a profession, because essentially what it means is that you are competing with some staff in NAFDAC who is taking 30,000 naira from people to register trademarks for them. You are competing with some other guy who just hangs under a tree by the Trademark and Patent Office and all of that. So it's unfortunate, but that's where we are at the moment.
Okay. Thank you so much, sir.
Sorry, if I can add to that, yeah. Just from your experience, Max, when this started with CAC, I was one of those persons who was really, disturbed, and I was, annoyed, especially for, people who felt I did my NYSC in Abuja. And I've, just some of these stipends. I mean, I was working in a firm, but, that one could go get by with. But at the end of the day, I feel that whatever revolution they did at CSC, and which is one day going to come generally at the trademarks registry, it has scripting, everybody is now allowed to do that. But when the real revolution comes in, when AI sets in terms of filing, one thing which I felt it did was that when people say it took away work from lawyers or from practitioners, I feel that what it did was to give us a room for rethinking. So one thing which I would encourage all of us here is beyond just being an accredited agent or having a portal to file, that it's also, because it will come one day, right? It's an opportunity for all of us here, including myself, to think about creating other avenues that will make you stand out as a lawyer and as an IP practitioner, that would, creating value for yourself. So beyond just filing trademarks, because that's the normal thing most practitioners are coming, you are just marketing yourself in order to be able to file trademarks. Have you acquired expertise in certain areas that, and I tell you one thing which would happen. I know that one of the South African law firms, was that's where the real competition is actually. You can't actually compete with them. I'm thinking of any Nigerian firm that has gotten to that level that would compete, because these are firms that have been there for more than 100 years, that would compete with some of the very prestigious South African law firms. I'm not even talking about England now, So when they now come to start acquiring law firms in Nigeria, I know one that has acquired a law firm in Abuja. So when they start acquiring, that's when we start seeing the real competition. So the question you have to ask yourself is, what do I do as a lawyer that will make me stand out beyond, because very soon when this competition comes, when AI comes in, that somebody in South Africa, somebody in Johannesburg, in Pretoria, or somebody in Mauritius, or somebody in London or Jersey can sit down and file their trademarks without needing you. What would you as a lawyer, as a practitioner now have that would still make you relevant within the scheme of things? Things like what Mr. Marx has said, these new age areas relating to, because some of the older ones, IP litigation and dispute resolution might be something you will start competing with some of the very old traditional law firms here in Nigeria who have been there for 30, 40 years. So, but there are some of even the new areas, the internet area, the areas that relate to internet, all these domain name issues, online mediation, online arbitration. For instance, JIIPCC, they have a very active arbitration center and a very active ADR center. So these are some of the skills that we should, things like anti-counterfeiting. I mean, I know that I've been decrying the fact that Nigeria is, a hub for counterfeiting and all that. But I mean, from a practitioner's perspective, that means that there is a lot of opportunities for you to specialize in that area and for you to acquire expertise in counterfeiting and in anti-counterfeiting, and market yourself and make yourself relevant in that sphere. So if there's one thing which I would want us to take away from this, is that, you have to move out from, because it's coming and it's coming very soon, that your relevance as an IP lawyer who files trademark, who files patent, who goes to do notification at the copyright NCC, would no longer be relevant, because somebody can sit down from the comfort of his laptop and do it from himself. So the question then becomes, what do you then have at that particular point? So I encourage each and every one of us to acquire expertise that will make you relevant in the near future. Thank you.
Thank you so much, sir. Thank you. So I want to thank other mentors that have come, Mr. Folarin, Mrs. Regina, and Mrs. Tala. Thank you so much for dropping by. So I'll pass it on to Mrs. Juliana to give final.
Okay, thank you very much, Mr. Amala. Thank you, Mr. Max. Like, today's session has been so interesting, sincerely. It's one of my best sessions. It has been very practical and very interesting. And I don't think it would be good for us to just go without allowing Mr. Max to say hi and sorry, Mr. Folari to say hi, Mrs. Regina to say hi, and Tala to say hi. Please, we want to hear your voice before we go. Your voices before we go.
I'm sorry, let me add that when they come up, please, they should help us tackle this question asked by Amusa, this distinction between industrial design and copyright. And then also Amusa should be listed as one mentor, because even me, he has given me assignment. As I go back now, I'm going to study on that distinction again properly. Thank you.
Hi, this is Regina. I didn't really get that question. I had a little bit of internet issues that.
Okay, that's the distinction between copyright and industrial design. Sorry, the question was the distinction between copyright and industrial design. And I think that Mr. Max has dealt with it properly, and Mr. Mala. But if there's any other thing you want to add, you can also add. So we can hear from Mr. Folarin, Mrs. Regina, and Tala.
I think Mr. Max dealt with it, and the little bit that was left was decimated by Amala. Yeah, no pun intended. But I think it's just the copyright component, or the similarity. To be more specific, industrial designs are visual. So it's the artistic work element of copyright protection that it speaks to. And I mean, they said everything. It's, but okay, I think one should also make a distinction between pattern industrial designs and, so by pattern, so that relates to textile. So textile industrial designs and, other types of industrial designs. But I think they said everything, so it's that artistic work component of the Copyright Act that it deals with. Well, good evening, everybody. Nice listening to everyone. I met Amala many years ago when I was still very young. I'm still young, but he has become a big man. And of course, Oga Max is always our Oga. So nice listening to you, sir. And man, that's stuff on arbitrability. I'll go and look for where you spoke about it, or if you have a recording, please, I would like to listen to that. Because I also share, anyway, let's not go into, I have similar thoughts, but you've broken it down. Maybe I'll come for personal tutorials. So thank you very much. It's always a pleasure listening to the mentees. Well done. Thank you very much.
Thank you, Mr. Folarin. So I don't know if Regina would still like to speak, or Tala. Okay, so maybe they've already heard so much and they would like to just think about it. Thank you so much, sincerely. I enjoyed this session, and thank you, Mr. Amala, for putting your video on. When you were first talking, it was off, then you now put it on. Thank you for allowing us to see your handsome face. And I would like to say a big thank you to Bernice for anchoring this session. She has always been amazing when it comes to anchoring. Thank you. And to all those until this time, Esohe, Gabriel, thank you very much. Let's continue to have an amazing time and weekend, and let's continue studying. So next week we'll be studying TK, that's traditional knowledge, cultural expression, GI, that's geographical indication, and all those topics. So let's prepare and come next week Friday. Thank you very much, everyone. Take care. Have a good night's rest. Bye.
Bye. Thank you.
Thank you. Yeah, sorry, before we go, let us not forget that there is private one-on-one mentorship available. So if you know that you want to meet Mr. Max one-on-one, you can fill that link. If you want to meet Mr. Mal, I'm going to send it to him later on. If he has the time, Mr. Folarin, Regina, all of them have indicated that they can spare 30 minutes out of their time once in a while to listen to us. So please take advantage of this opportunity. There's some things that you can't say here that you might want to speak with them directly. So thank you very much. Bye.
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 Bye. Thank you.